Welcome to episode 27 in the first season of Justice Center Weekly from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me today is lawyer Allison Pejovic, who recently returned home after spending the first part of her week in Ottawa at the appeal hearing of Brian Peckford, Maxime Bernier, and others as they sought to overturn a ruling of mootness in their case against the federal government for the vaccine travel mandate. Allison, not everybody knows what mootness means. Maybe we could start with that. And then tell us about your arguments.
Sure. Thanks for having me here today, Kevin. So basically what happened was we were all set to go and argue our charter case about a year ago. The case was set to be heard challenging the travel vaccine mandate for airplanes. October 31st, I believe it was supposed to start a year ago. And the Prime Minister and the federal government removed the mandate in June of 2022 with an announcement that it had been suspended but could be brought back if circumstances arose and that they would not hesitate to bring it back. And the Crown, the federal government respondent, filed a motion for mootness to have our case struck because it was moot, meaning that the mandate is gone. Our clients have the relief that they sought all along. They can now fly, so there's no need to hear the case. And so we sent a team to Ottawa in September of 2022 to argue that point. I was not one of the ones who argued it the first time because I was getting ready for the big charter hearing, which was to take place a few weeks later. And unfortunately, the federal court, lower court, ruled against us and granted the federal government's motion to dismiss our case for mootness. And so basically it was a finding that, there's no more live controversy, meaning the mandate has been lifted. And there's a Supreme Court of Canada case that guides litigants and courts in terms of whether a judge should hear a case based on whether it's moot or not. The first part of the test is there a live controversy? And the second part of the test is, even if the judge finds there is no live controversy, that the case is moot, the judge can still exercise discretion to hear the case in any event. And if there's a variety of factors that judges consider, according to the Supreme Court of Canada, having to do with, is there public interest in the case that to such a level that it would outweigh the number of days that the judge would have to hear the case and the resources it would take the courts to hear the case. And there's other factors such as, are the parties still in an adversarial, adverse to each other? And the court has to consider its judicial role, whether it would be going into the political sphere by making a decision on a moot case, or whether it is exercising its proper role. And so, unfortunately, the judge found that there was no live controversy, and also she exercised her discretion not to hear the case. And she said in her judgment, which is one of our grounds of appeal, that the public interest was alleged. And I mean, one of the points that we argued was that this case has a greater public interest than perhaps one of the greatest cases in terms of public interest in Canadian history. There's lots of other cases with important issues that come across the desk of the Supreme Court of Canada, for example. But in terms of a case that affects, we would say, every single person in Canada, not just unvaccinated people. And keep in mind that the number of unvaccinated people who could not get on an airplane during the time of the COVID mandate, it came out in evidence it was about 5.2 million people. But it's not just the unvaccinated people, because there are vaccinated people who perhaps wouldn't have got the vaccine, but for the fact that they wanted to go on a winter vacation, they wanted to go see their families overseas, they wanted to, travel on an airplane to get across country for work. So those people, we say, would want to know whether that mandate was lawful. I mean, some people were happy to take the vaccine. Some people would never take the vaccine, and some people took it because they felt pressured due to the mandates. So, and obviously these mandates tore a lot of families apart. So, our argument was that everybody would be interested to hear the outcome of the case, to have a judge go through the significant evidence that we put forth and that the Crown put forth. Combined, we had, I think it was 13 or 14 affidavits. The Crown had numerous witnesses, government witnesses, to testify about the various COVID response and the need for the mandate. We ourselves, our group of Peckford appellants, had 5 expert witnesses, and our co-appellants had another 4 expert witnesses. Then between our 2 teams, we had 9 doctors/scientists. And the government, of course, responded with their own team of doctors and scientists. So, we had 6 weeks of intense cross-examinations, and very important evidence came out, we would say, on both sides, that we asked the court to hear. And it's very important that Canadians know, in our view, whether and to what extent Section 6 of the Charter, which is the right to enter Canada and leave Canada, to what extent that right actually protects Canadians. Is it actually a freedom to leave whenever you want? Or is that right, can that right be conditional upon receiving what we say is, a novel medication that the evidence came out from the government, actually, in this case, that the vaccine was still in the testing phase. It hadn't finished its phase 3 testing. That was from Health Canada's expert. So very important issues. Section 6 of the Charter is a charter right that's not subject to the notwithstanding clause. It's a strong fundamental right, and hasn't been litigated to this extent. And in a case like this ever, we've never had a situation where the federal government, essentially has locked unvaccinated Canadians in the country because they really couldn't leave unless they wanted to swim across the Atlantic and Pacific Ocean, unless they wanted to take a canoe to see their families in South Africa. Like one of our clients had family in South Africa she couldn't visit. If you wanted to take a dinghy all the way to England, another one of our clients had a home in England. That was open to you, but obviously that's at your own peril, and they would for sure perish along the way. So they're really, Canada, for all intents and purposes, is our clients' homes. But unlike the rest of the world, who were flying around to countries who were open to vaccinated people, Canadians weren't allowed to leave. But foreign nationals, interestingly enough, were allowed to leave on airplanes.
Okay, I have a question, though, about this term public interest, because I seem to, in my own mind, define it 2 ways. One, that the public is interested, and the other, that it affects the public going into the future. Now, am I wrong in either one of those, or which is the one that they weigh, that it's going to affect the public going forward, or that they are simply intensely interested in the topic?
Well, it's really the former is the stronger argument, that the public has an interest in finding out the legal landscape in terms of the charter rights. And also, I have to note, it wasn't just a charter case. It was also a case where we argued a jurisdictional legal issue, which is, did the Minister of Transport have the authority under the Aeronautics Act to make these orders which prohibited unvaccinated people from getting on airplanes? And our argument, that argument had nothing to do with the science. That argument was basically, did the Aeronautics Act give him the power to make orders under public health, really? And we say that that was unlawful, that the wording of the act does not permit him to make orders like that. So that issue was left undecided. And Maxime Bernier, who's also one of our appellants, he had a unique argument. He argued that not only was Section 3 of his charter rights infringed by the vaccine mandate, which is the right of Canadians to participate in the political process, but also that the mandate violated his rights under the Elections Act. So we had a variety of legal arguments here, and the judge in this case, she focused 100% on the fact that this was a constitutional case, and she made comments and in her analysis that this is a constitutional case, that the law is not uncertain, meaning that, and she cited a bunch of cases that were COVID-related cases. She said the law is not uncertain, and so these orders wouldn't be evasive of review. But those COVID cases that she cited had nothing to do with Section 6 in the context of the air travel vaccine mandate. And they had absolutely nothing to do with the jurisdictional argument as to whether the Aeronautics Act gave the Minister of Transport the power to do what he did, or the Elections Act issue. So, getting back to the legal test, we say that the errors were made in the discretionary test as to whether, and it's a balancing test. So there are three parts to that test: whether there's an adversarial context, whether the concerns for judicial economy are outweighed by the public interest, and whether the court would be exercising its proper judicial role. And we say she made a lot of errors in her analysis with respect to those three branches of that test. Number one is that she didn't write anything on the third branch of the test. So she missed part 3 of the test, which we said was an error of law. And it's easier to get a decision overturned if a judge has made an error of law. If a judge has made an error of fact, it's a lot more difficult to get a decision overturned. So, our strongest argument was that she made an error of law in neglecting to attend to the third part of the Borowski discretionary test. We also, as I said, pointed out that she was wrong when she said that the law is certain on these COVID tests, and there's no need to hear this one. This one is very unique. It would be precedent setting. And also the public interest is not alleged. I mean, why did Canadians drive all the way to Ottawa for the Freedom Convoy? And why did we have Emergencies Act inquiry talked about the reason that people went was because they were upset about the COVID mandates, and the federal travel mandate was, I would say, top of that list. So the public interest was huge, and Canadians, in our argument, really have to know whether they live in a country where it is lawful for the federal government to say you can't leave the country unless you've taken a novel vaccine. And if that is the case, we would argue that Canadians with family overseas, we would say they would be considering whether to move to where their families live out of the country, because if this comes back or another virus comes and they have a new vaccine and this kind of mandate is reintroduced, they may want to be where their families are, or they might want to get their families to try and move here somehow. But these are very important. This is very important information and guidance that we're asking the courts for, and so it's deeply troubling from a sense of obtaining justice and the administration of justice for the appellants and the 5.2 million unvaccinated Canadians behind them, to know what their rights really are in Canada, especially the Section 6 mobility right, which is fundamental to each person to be able to come back into and to leave their own country.
Yeah, well, part of what I had asked earlier reflected the notion that when this thing was withdrawn, there was some kind of threat from the Minister of Transport to bring it back. And I think that's where there was some uncertainty, and that's why I was talking about the future.
Right.
Was that highlighted at all in your appeal?
Yes, the lower court basically didn't agree with us the first time that she could really do anything with the federal government's threat to bring back the mandate. She said, well, hopefully this will never be repeated, and there's no legislation in place, and they actually haven't done it. So I, really can't really consider that. And we really only have, a press conference where this was announced that they might bring it back, but there's really nothing more here I can work with. Whereas we had a decision from the BC Supreme Court, which was just upheld on appeal on Friday. It was called Cassian versus Dr. Bonnie Henry in British Columbia, and a decision from the Ontario Superior Court of Justice on the Harji case, which was a challenge to the Ontario vaccine passport mandate. Both of those decisions took into account in the discretionary analysis as to when the judge says, well, I'm going to weigh the factors and decide whether I'm going to exercise my discretion to hear the case. The judges in those cases took very seriously the threat to bring back the mandates, which occurred in British Columbia and in Ontario, where the government couldn't say that they weren't going to bring it back. And the judges in those cases said, yeah, no, that's a very, very strong factor here, and we're exercising our discretion to hear this case anyways. Even though the mandate is gone, it's worth hearing because of this threat. And the judge in this case decided, she didn't even consider that in her analysis of whether to exercise her discretion. And we said that was an error as well, because she just completely left it out of her analysis.
Yeah, actually, I had spoken to another lawyer, Marty Moore, on the other podcast about that case that occurred in BC. And I'm wondering if you had a chance did you actually have a chance in court to refer to it? Because it was so recent.
Yeah, so we referred to, that case the oral decision was given in court on last Friday, and we appeared in court this week on Wednesday. And all we could say was that a decision was rendered and the appeal was dismissed, meaning that the appellants had won on the mootness issue. But the case there were no reasons at the time that we could hand up to the court. But just yesterday, the court posted to its website the written reasons. So we sent a letter to the court yesterday and provided them with the decision. So hopefully, at least they'll have another decision to consider when they're deciding which way to go with our case.
I'm wondering if I could ask you to maybe just summarize the case against you. What kind of arguments was the government putting forward against your appeal?
Well, they argued that the judge did everything right, that she didn't make any errors, that the public interest was not there to the extent it would need to be there in order to overcome the fact that we would be spending 5 days in court and the judge would have to read 14,000 pages of evidence, and it's just not worth her time when the mandate has been lifted. So basically just that the judge did everything right, and they also focused on the fact that there was no live controversy because one of our co-appellants, Sean Ricard and Carl Harrison, they were arguing that there is still a live controversy, that the parties are still entitled to what's called declaratory relief, which is a declaration from the court that their charter rights have been infringed. They argued that was still a live issue. We agree that's a live issue, though that wasn't what we argued. We decided to focus on the second part of the test, whether the judge should exercise her discretion whether she should have exercised it in terms of finding that she is going to hear our case. They focused a lot more on the live controversy part. And the federal government's argument was, there is no live controversy, the mandates are gone, and, Federal Court of Appeal, it's not your role to decide whether it's not your role to hear this case, basically, because the mandates are gone and there's no need to hear this case, and you shouldn't be granting a declaration in the absence of a law or order that's still in force. So, they argued very, very similar to what was in their written arguments, and basically just told the court, we really don't need to be here. You really don't need to grant this appeal. There's no need for you to intervene here. The lower court did everything, fine. There's no errors. And so another one of the points that I wanted to make was that the lower court suggested that we should be bringing a statement of claim which is different than what we did here. What we did was we brought a notice of application for judicial review.
Right.
And that is a process that proceeds much more quickly than a statement of claim. A notice of application, we had it filed at the very start of February in 2022, and we had a court date for October of 2022. So it went very quickly. Both the government and the appellants moved very quickly. Nobody delayed. We had our cross-examinations intensively in 6 weeks, and we were ready to go in less than a year. If you file a statement of claim, it takes a lot longer to get through the process. And whereas we were scheduled to be in court for 5 days, if you're in a trial situation, you can be there for weeks. So the court suggested here that in her analysis of, how do we preserve judicial economy, that we should have brought a statement of claim, which would mean that it would use up far greater court resources and far greater court time. It would be weeks in court for a judge if we had brought a statement of claim, as opposed to 5 days. So we argued that that was an error in her analysis when she's saying, in judicial economy, this would preserve judicial economy if you would have brought a statement of claim. That's just false.
Right. It would have been a worse use of the judge's time, or
that's right.
A much longer period is what you're saying. So
that was our argument.
Right. Okay. That's good. How many total clients did you have here, and were they, a lot of them using or prepared to present separate arguments, at least in the initial trial?
Yeah, I mean, I had 6 appellants that were in the group called the Peckford Appellants, which was led by the former Premier of Newfoundland, Mr. Brian Peckford. And we had Mr. Ken Béjean came to Ottawa to watch this appeal. And Miss Natalie Gerchich also came to Ottawa. She was a client who has family in South Africa, and she couldn't go and see. And so those, we had six appellants with the Peckford appellants. 2 of them came to the hearing. They all swore affidavits, and the respondent government decided not to cross-examine any of them on their affidavits. So their evidence basically stood unchallenged, and they outlined why they thought their rights and freedoms were infringed. And we represent Maxime Bernier in a separately filed application, and he was also there in Ottawa with us this week, and he also filed an affidavit outlining why he believed that his charter rights were being infringed, and also his rights under the Election Act, as he's he's a leader of a federal party, and he's trying to grow his party, and his political opponent puts in an order basically preventing him from flying across the country. And it really prevented him from being on an even playing field with his political opponents. And so our argument was that was counterintuitive to a functioning democracy. So those issues are very important for the court to rule on. And so it's extremely disappointing, and not just for the appellants, but for Canadians as a whole, because, again, Canadians need to know the legal landscape around these very important issues. Can a political opponent basically prevent his opponents, his or her opponents, from campaigning? And that's just one of the many important issues in this case.
Well, I suppose it could be tried in the court of public opinion, but that kind of is where I'm going to go with my next question. After that court case was ruled moot or irrelevant, what became of those 14,000 pages, including all that expert testimony? Does it go public? Are you allowed to send it out to the public so they could read it all if they felt ambitious and wanted to judge for themselves?
Yeah, well, when we originally filed that material, the Justice Center for Constitutional Freedoms, which is funding the case, had it posted, in a news release. And so that's on the internet. It's on our website. You can click. It takes a long time to go through everything, but it is on the internet. And I believe that our co-appellants, represented by different counsel, Carl Harrison and Sean Ricard, also posted those 14,000 pages on Twitter. So it is out there. It's certainly not subject to any publication ban. That evidence is public, and people can find it online. They could certainly go to the federal court and ask to review it there, just like evidence in any court case, as long as there's no publication ban, as long as it's not sealed for any reason. So yeah, it's a real shame because there's very important information that came out during those cross examinations, and it's very it's really unfortunate that when you have experts on both sides who spent hours putting in their time, drafting expert reports, pulling all the available science, they take time away from their jobs and from their families to, write an independent expert report summarizing their positions and on these very important issues, only to have the case not heard. In our view, that's it's counterintuitive to the proper administration of justice. The case should be heard. They're very important issues that are very Canadians need to know. They need to know whether what the government did here was lawful, and part of that, the answer to that question, a lot of the answer to that question is found in the science and what the judge does with the science on this case when it comes to the constitutional issue. When it comes to the jurisdictional issue, as I said, the science doesn't matter, or the Elections Act issue. But when you have an order like this that is this divisive, causes families and friends to split from each other and separates people across oceans, it's highly distressing that the case is not able to be heard and be properly adjudicated.
Yeah, I'm wondering how long it's going to take for them to come to a decision on this appeal. I suppose you aren't given any indication at this point. No,
I mean, the justices told us as we were wrapping up that they would get a decision as soon as possible, but judges are busy people. They have a lot on their plate, so we could be waiting. We could be waiting months. I've waited 6 or 7 months for a Court of Appeal decision. That's not abnormal. So, once we get the decision, depending on which way it goes, we'll decide what our next step would be.
Well, if they decided against you, what would be an available step? Can you push it upwards to the Supreme Court at that point? Yeah, I mean, with the Supreme Court, it's difficult to get heard by the Supreme Court because they only take approximately, I'm going to say, and I looked at that stuff before, about 60 out of 700 applications annually. Right. So a very small number of cases make it up to the Supreme Court, and you have to convince the Supreme Court of Canada in a written application why your case has national importance, and they decide amongst themselves which cases they want to hear. So that would be an option for us to attempt to take it up to the Supreme Court, but there's no guarantee that they would hear it. Obviously, at the top of the list of reasons would be it affected 5.2 million Canadians directly. Yes. Okay, well, thank you so much, Allison, for taking the time to fill us in on your trip, and I hope the jet lag has cleared up already. I hope to actually... What's that? I said almost. Oh, good. All right. Well, I hope to speak to you again soon. Great. Thanks so much, Kevin. Have a good weekend. You too.